I'm here with Mark Simpson, partner at Cooley. It's great to have you here, Mark. Thank you for coming to the conference.
Great to be here, thank you.
Hope you're enjoying it so far.
Very much so.
So I have a couple of questions for you. You ready?
Certainly, let's go for it.
Okay, so do you see differences in how the UK and EU authorities approach big tech investigations?
Yes, well, increasingly now. I mean, historically, what we used to see, of course, pre-Brexit, was that the European Commission had preeminence in conducting investigations into basically the biggest cases, and that would involve big tech, and they opened and concluded a number of investigations prior to the UK leaving the European Union. Immediately after the UK left the European Union, what we saw was the CMA open a number of investigations against big tech in relation to app stores, in relation to ad tech, and in many ways, those were parallel to and being conducted in lockstep with the European Commission's own investigation. But what's changed since that time is two things. One is the use of, or the continued use of competition powers, and the second is the introduction and bedding down of digital regulation. Mm-hmm. So if I deal with the first issue, that's the continued use of competition investigation powers, the European Commission and the CMA have looked at big tech in terms of the abuse of dominance prohibition. Now, starting with the CMA, what they did in 2024, when the digital markets legislation in the UK came into effect, was they closed two ongoing investigations concerning app stores on administrative priorities grounds, and they justified that because they decided to look at those concerns under the new digital regulation powers. Meanwhile, though, if we look at the European Commission has continued some of its already open competition investigations in relation to big tech, moved those forward, defended existing decisions on appeal, and at the same time rolled out its digital regulation powers, and it did so much quicker. Where the CMA, although their legislation came into effect somewhat later, they had been rather slow in designating the first two big tech companies that were only designated over the summer, and subsequently they are still to decide what the ongoing obligations are and to consider any enforcement action. But the key thing is that they won't be looking backwards in terms of what went before. But with the European Commission, as I said, they've continued investigations. At the same time, their Digital Markets Act regulation is much more advanced. They had, by the beginning of this year, already designated 8 of the big tech companies under that legislation. They've conducted numerous investigations for non-compliance, and they've imposed some very hefty fines against some of those big tech companies. So that's the key difference now. We have European Commission moving forward quickly, using both sets of powers. The CMA in the UK on a somewhat slower track, one might say, being much more hesitant. And I suppose there's quite an interesting point in relation to how the CMA might justify moving forward slowly, and that it has been suggested might be because at the same time we've seen numerous cases against big tech in the Competition Appeal Tribunal under the class actions regime. So there is a school of thought that private enforcement has stepped in the UK in the place of the CMA.
Okay, so there's very interesting differences then between the two.
Indeed.
So what's changed most in how companies prepare for potential competition investigations?
That's a really good question. Advising companies on this, one thing that's constant is urgency. Companies have always wanted urgency in terms of thinking about the consequences of an event such as a dawn raid, such as receiving a request for information from an agency or discovering perhaps through a whistleblower that there's been a compliance issue. They want to understand what the implications are and what their options are. But what's really changed, I would say, in the last 5 to 10 years is that companies are looking beyond the agency investigation. It used to be that the concerns were about how much is the fine? How can we reduce the fine? Is there leniency? Would we be first in a queue? Questions about reputational harm, questions about how can we deal with our customers and managing the PR around this. But now very much at the forefront of all companies under investigations is the spectre of private damages claims. It might be their customers are probably going to sue them. They have to factor that in. It may also be indirect claims, and it may be, and this is the big one, class actions, because they know now through all the publicity that plaintiff firms are very alive to issues, are very live to investigations opening. Funders are interested in funding these sorts of claims. So that needs to be factored in very early. And that does change the calculus, because applying for leniency with the CMA might get you immunity if you're first in from the administrative fines, but it won't get you immunity from the damages that might follow in subsequent private cases. Now, there is one provision in the UK legislation which says you can have immunity from joint and several liability, say in a cartel situation, but that doesn't actually excuse your liability for your own conduct and your own sales. So it's interesting, the CMA seems to be alive to this. They've recently amended their leniency guidelines. Those changes really just tinkering around the edges, and I don't think they're going to change the calculus. But what is interesting is that almost at the same time, they put in a response to the government's consultation on the private damages regime, and specifically the CPO regime, the class action regime. And they noted within that a change would be helpful for leniency and encourage more leniency applications if the legislation provided for full immunity for immunity applicants, so people who are first in to disclose the context and details of an investigation to the CMA, that not only do they get immunity from fines that the CMA might impose, but also from damages in private litigation. And I think if the government takes that seriously, that could really shift the dial.
Very thoughtful answer. Well, thank you very much for allowing me to interview you, and I hope you enjoy the rest of the conference.
My pleasure.